what in the world happened there? It's been too long since I've done this. Everybody, welcome. I'm Paul Lathrop. I'm your host. This is Polite Society News. We are. I put Polite Society to bed a while back and decided that I would just come on when I felt like there was something important that has happened that I wanted to come on. I wanted to talk about. And yesterday, this week, a couple things have happened. Yesterday, I reached out to Alex Ooley. Alex was gracious enough to go ahead and say, yes, I'll come on. We'll talk about these things. The reason I asked Alex is because both the things that hit my radar that I want to talk about are in the legal aspect of the Second Amendment. And so let me finish getting social media hooked up here. And I believe I have everything hooked up. Let me take a look here. There we go. And yeah, we're already getting check-ins happening, so I know we're out. We're getting viewers. So, Alex, let's go ahead and get into it. First story: there was a win in, at least temporarily, in California. The May versus Banta and Carello versus Banta lawsuits. Apparently, both went before the same judge. Apparently, both were decided at the same time. And this judge in California gave a really big victory to us in sensitive places designations in California. I've got a whole list of places here. I'm not gonna at least initially read them all out. I would imagine this looked about as good to you as it did to me, man.
Oh yeah, absolutely. It was certainly a win, but like you say, temper that a little bit because it could be a temporary win. It was in a district court in California, and as we know, the example we had from, I think it was the Duncan case, the high capacity magazine case, the Ninth Circuit relatively quickly stayed the injunction that was issued in that case. Of course, the advantage here is that unlike the Duncan case, which was at the Ninth Circuit on a rehearing, because the case had actually been filed before the Bruin decision was decided by the Ninth Circuit, before the Bruin decision, and then got kicked back after the Bruin decision came down in June 2022. This case is a newer case and is not a rehearing, so that the Ninth Circuit won't have the same excuse to sort of bypass the normal procedure in the Ninth Circuit when it's being heard by a panel there. So they sort of skipped their traditional process in the Duncan case. I don't think they'll have quite as easy a time doing that here, but I'm not holding my breath. But I think it's kind of a shot in the dark about whether this case is going to be, the injunction rather, is going to be upheld once it's appealed to the Ninth Circuit. But nevertheless, it's certainly a win. Hopefully it's not just a temporary one.
Yeah, absolutely. And I am going to go and I'm going to read just a little bit of I've got an excerpt from the story that I got off Bearing Arms. The places that the injunction was granted for, where you previously could not carry, that you now can, and I'm going to go through just a partial list here: hospitals, mental health facilities, nursing homes, medical offices, urgent care facilities, and other places where medical services are customarily provided, public transportation, establishments where intoxicating liquor is sold for consumption on the premises, public health gatherings and special events, playgrounds and private use centers, parks and athletic facilities. The only thing I do not see here that I seen that is worse in cases like specifically New Jersey. In New Jersey, you were not allowed to carry in your private vehicle on a public road, which basically outlawed carry in New Jersey entirely. I don't see that here. I would imagine that would have been part of what was sued for if that were part of the California law.
Yeah, no, I agree with you, Paul. And I actually went and looked at the text, the entire text of this bill that was being challenged, which was SB 2,
Hmm.
Senate Bill 2, and there were 29 prescribed areas that were considered sensitive places. And of course, I think it's helpful to remember sort of the big picture here in the wake of Bruin. Of course, Bruin was a challenge to what sorts of people can carry a firearm. Remember, it was challenging the the New York.
Doggone it. Sorry.
Oh, you're good. Remember, the Bruin case was challenging the proper cause requirement to obtain a license to carry a firearm in New York. So it was about what sorts of people could carry a firearm, and whether or not the state had basically absolute discretion in deciding or who didn't have proper cause or a good reason to carry a firearm. Uh, and of course, the Supreme Court struck down that law. But in response, you alluded to New Jersey, obviously New York, and some other states, including California, uh, came up with these Bruin response bills. And one of them is these sensitive place bills, where they basically say, okay, well, if the Supreme Court isn't going to let us say who can carry a firearm, we're gonna basically outlaw where they can carry. So an example like this SB2 basically prescribes nearly every place in the public and a lot of places in private, like an establishment that sells alcohol, uh, as a sensitive place where a firearm cannot be carried. So they're essentially gutting the right to keep and bear arms, but through a different mechanism.
Yeah, this was a lawsuit that was brought. California Rifle and Pistol Association, SAF, was a backer, as was the Firearms Policy Coalition. The I want to make sure I'm right here, because there's Firearms Policy Coalition and Firearms Policy Foundation. I I use them interchangeably. I don't know if that's correct or not, but and I love. I got to get this. I got to get this in from MK. I got to get this comment in. He says the only sensitive place to carry is appendix carry. Well, and I mean, come on. Appendix carry. I just as somebody who's been around concealed carry for a very long time, there's absolutely nothing wrong with appendix carry as long as everything goes right. Now, having said that, digging a little deeper into that, you're going to get just as injured if you're strong side carrying as you are appendix carrying if something doesn't go right. So wherever you carry, train, and it'll be just fine. I know a lot of people that do appendix carry.
Exactly. Yeah, and one thing that's interesting about this case, Paul, is that number one, like we already alluded to, is what's the Ninth Circuit going to do with it? It's my understanding that there are a significant number of conservative justices on the Ninth Circuit, so there is a chance that the Ninth Circuit will uphold the injunction depending on which judges are selected for the panel that's going to review the inevitable appeal of this case. But the other thing is that this case, what's interesting about the opinion is obviously the court here, the judge, Judge Carney, analyzed each of these sensitive places that were challenged based on the test given by Bruin. And so obviously, the court has to look at the text first. That's the text of the Second Amendment. And does the challenged law implicate the Second Amendment? And if it does, the burden shifts to the government to show that there's a history or tradition of firearms regulation consistent with the Second Amendment that's analogous and relevantly analogous to the law that they're proposing to uphold. And so the judge went through that analysis, which with each of these sensitive places, so-called. And one thing that we're looking at the Supreme Court for in this Rahimi case is what sort of analogy is going to be close enough or relevant enough. And obviously, we're supposed to look to 1791 when the Bill of Rights was adopted first, and then only secondarily to confirm what we learned from 1791 to the period after the 14th Amendment was adopted during Reconstruction. So That's partly what's interesting about this Rahimi case is, of course, in Rahimi, which is at the Supreme Court, the court already heard oral argument, is expected to issue a decision sometime in the spring term. Uh, we're going to look for guidance from the Supreme Court about what sorts of analogies are close enough, because obviously, I think with the Rahimi case, which challenges the statute 18 USC 922 G8 prohibiting people subject to a domestic violence restraining order from possessing a firearm, those were only issued after a civil determination. That means by preponderance of the evidence, more likely than not. And whether or not, and there was no exact analogy to that sort of prohibition from the time of the founding, from 1791. But remember, we're not looking for a historical twin, as the court calls it. We're looking for relevantly similar. And so we're gonna find out from the Supreme Court, at least to a large degree, what they mean by that in their Rahimi decision. But here in the May case, the May v. Bonta case, the court was grappling with that issue and trying to look at analogies from the history from the time of the founding and then also from the time of Reconstruction. So that was interesting, and I think it's an interesting read for that reason. But ultimately, what analogies are good enough or close enough, we're going to find out from the Supreme Court.
Now, I did not read the entire decision. I'm basing my knowledge of this decision from a Cam Edwards story on Bearing Arms. But Cam writes that from one quote from this Judge Carney, he described SB2 as repugnant to the Second Amendment and openly defiant of the Supreme Court. The law turns nearly every public place in California into a sensitive place, effectively abolishing the Second Amendment rights of law-abiding and exceptionally qualified citizens to be armed and to defend themselves in public. Those are some pretty strong words, Alex.
Oh yeah, absolutely. The judge did not mince words in this opinion at all. And if it's okay with you, Paul, I'll read just the first paragraph from the
Sure.
introduction to the opinion, because I think you get a sense for where the judge is going right off the bat. He didn't hide the ball here at all. He says, "We live in dangerous times. Nearly every day we are barraged with stories about school shootings, attacks on places of worship, and other unthinkable acts of violence and cruelty. Nor are our society's problems limited to those acute acts of terror. Daily, our country faces prejudice and division of all types, economic uncertainty and poverty, a nationwide mental health crisis, and an epidemic of addiction and crime. The only hope to find in the face of such dire circumstances is that democracy, as it has up to this point, will prevail and somehow solve the challenges we face. But such hope is little comfort to individuals who, through no fault of their own, find themselves beset by an attacker and facing their death or that of their loved ones. The right of self-defense and to defend one's family is fundamental and inherent to our very humanity, irrespective of any formal codification." So I'll stop there, but that introduction, like I said, he's not hiding the ball at all. He's saying up front, the right to self-defense is inherent to our humanity. That is, it has nothing to do with the Second Amendment. It existed, and our right to self-defense existed prior to the United States. It existed prior to the Constitution or the Bill of Rights. It exists as part of our humanity. And here, the state of California is trying to take that away by saying we can't carry or exercise our right to self-defense by virtue of carrying a firearm almost anywhere in California. So that certainly is a disregard, not only of the Supreme Court and their decision in Heller, McDonald, and Bruin, but also of our humanity. And it's sad to see what the government in California is up to.
Well, the scope of this right now is just California. Washington's got designs on sensitive places, as does Oregon, which are also in the Ninth Circuit, but this has no bearing on anything going on the East Coast. For example, in New York, New Jersey, Maryland, any of the places on the East Coast that are doing similar things. How long do you think before this? Do you think this will make its way all the way to the Supreme Court? And if so, how long, man?
I do. I don't know if it will be this case in particular, but certainly one of the sensitive place cases will make it to the Supreme Court. I'm doubtful that it will happen this term, but hopefully sometime in the fall, the Supreme Court will grant certiorari to one of these, grant review to one of these sensitive place cases, because right now they're obviously they're grappling with Rahimi, which is, like I said earlier, the prohibition on people subject to a domestic violence restraining order from possessing a firearm. And in Bruin, obviously, they were talking about what discretion the state has with respect to the issuance of a license to carry a firearm, and what sort of powers the states have in that regard. So they haven't, but even if you listen to the oral argument in Bruin, the court was very concerned about sensitive places. They asked a bunch of questions about sensitive places, even in the Bruin decision, even though that wasn't really at issue in Bruin. So I think the court is going to be really interested in this issue. And of course, there are lots of cases maturing in various district courts around the country. So I think one of them will be ripe for the Supreme Court to review in the fall.
I do know I didn't. It was too long for me in my show prep today to be able to go through the whole thing. I do know you do have the entire Rahimi oral arguments up on Forge of Freedom on the YouTube channel there at least. You were you able to listen to the entirety of the oral arguments, and how do you think that went if you were able to?
Yeah, I was. I listened to it when it came out, and when the oral argument took place in November. I think it was November 7th. I posted it to the Forge of Freedom YouTube channel because I broke it down into chapters based on various arguments, so you could easily reach certain segments of the oral argument. It's difficult to read the tea leaves with respect to a case at the Supreme Court based on how the oral argument goes. But my impression was that it could have gone a lot worse, but I wouldn't say it went particularly well. Like I said, part of the issue is going to be how broad the court says an analogy can be for it to be relevantly similar. And they really focused on this notion of dangerousness. So they would say, for instance, that somebody who is drunk shouldn't be able to have a firearm because they were dangerous. Okay, so is that analogous to someone who is subject to a domestic violence restraining order, even if it's only after a finding by a preponderance of the evidence? Well, if they say yes, that's close enough, that's a pretty broad analogy, okay? Whereas if they said, no, we're looking for a restriction at the time of the founding based on a civil finding of some sort of dangerousness, then that would be a much closer analogy. So I'm not optimistic that they're going to take a strict view of what sorts of analogies are going to be appropriate. I think it's going to be sort of a mixed bag based on what I heard from the justices questioning.
I got one more story I want to cover today, and this is one I got off of AmmoLand, Second Amendment Foundation, and I believe this is another one where the Firearms Policy Coalition is involved as well. Have filed a lawsuit and moved for a temporary restraining order against a law that's going to be coming into effect on January 1st in California as well. And this law, speaking as somebody that works in video, or at least my hobby is in video, this law in California, just reading from the AmmoLand story, on January 21, 2024, California will implement a mass surveillance regime designed to catalog the faces, conversations, whereabouts, and shopping habits of millions of Californians engaged in constitutionally protected content. This audio-visual recording scheme will operate 24 hours a day, 7 days a week, 365 days a year without end. Basically, I'm going to synopsize this because we've only got, another 11 minutes before the bottom of the hour, which is traditionally when I try to get out of here. But I'm not going to worry about time quite so much. What California law says has to happen is every place where guns are sold, whether it be a gun store or somebody who has a FFL out of their home and are just doing sales out of their home, there has to be a video recording in every entrance, exit, every place there is, focusing on the point of sale and on displays of firearms, that records 24 hours a day, 7 days a week, in perpetuity, and those recordings must be kept for at least a year. I did a little bit of research on the fly here, and for as somebody who works in video, for you to have a 1080p recording of each individual camera that is you can bring up to a full display size for just entries, exit, display, and they also want internal and external views of the entrances. You're looking at 4 terabytes per day of storage, and that's there aren't a whole lot of computers. I would say the minority of computers have a 4 terabyte drive, period. They're looking at astronomical costs to anybody that sells a firearm. That this is going to essentially drive every firearm retail in California out of business.
Yeah, and like you say, I mean, that 4 terabytes is a day. That's with just 4 cameras, and to capture all of the areas that they're prescribing here, all entrances, exits, firearms displays, and points of sale. I mean, that could easily take up more than 4 cameras and 4 terabytes a day, very easily. But the other thing here is that the law, and this is SB 1384, says that gun dealers must purchase, install, and subsequently maintain this surveillance infrastructure and its voluminous data at their own cost for a minimum of 1 year. So we're talking about vast amounts of data, not just for one day. They have to store this data for a minimum of 1 year. So this has a huge chilling effect on, like you said, on gun stores, because it's going to cost them huge amounts of money to comply with just this particular regulation. And this is in the penal code. So this isn't just like a civil issue here. They're at risk of criminal liability if they don't comply with this particular law. But this is as the article says that you've linked to from AmmoLand, this is really Orwellian, of course, referring to George Orwell's 1984. Mm-hmm. I mean, they want to track and surveil people that they disagree with, so that they can keep tabs on them and punish them when they do things they don't like, even if it hurts no one. Well, so this is a terrible law, obviously.
Getting again from the AmmoLand story, but to make matters worse, California additionally compels its newly commandeered camera operators to display a message of the state's choosing on their properties, both commercial and residential. These premises are under video and audio surveillance. Your image and conversations may be recorded. And yeah, let's face it. I know a lot of people in our community are averse, which is why there aren't a whole lot of. There's several, but there aren't a whole lot of video podcasts that have to do with guns, simply because a lot of people don't want their image out there. And audio podcasts, I mean, there's more than video podcasts about guns and gun rights, but you know, the whole I don't want to be on a list is very persuasive, and California's going right after that as well.
Yeah, exactly. they're wanting to track people in all sorts of ways by requiring the registration of firearms, by bringing more firearms within the ambit of the NFA, by getting your picture every time you go in and out of and video and audio of you every time you go in and out of a firearm or an FFL. So these are, like the article says, very Orwellian tactics to suppress freedom. And I would note here, too, that the Second Amendment Foundation, along with a number of other organizations, including some of the ones we mentioned earlier, California Rifle and Pistol Association, Gun Owners Foundation, Gun Owners of America, etc., they filed for a temporary restraining order and a preliminary injunction to stop the enforcement of this law, which I believe is supposed to go into effect January 1st of 2024. So they filed that motion, but they also filed a memorandum of points and authorities to support their motion. And in this memorandum, they cite a number of constitutional violations, including violations of the First and 14th Amendment, violation of the Second and 14th Amendment, and then the Fourth Amendment, and then just plainly the 14th Amendment. So there are lots of ways where this law gets out of bounds with the Constitution and the Bill of Rights. So I hope that they can enjoin this law so that it won't go into effect on January 1st. But of course, we're coming up right on that January 1st deadline.
Yeah, absolutely. Only a couple comments in here. One from MK. He says, California should consider putting video surveillance on their border crossings.
I think we need more surveillance to see what the government is up to. I mean, they're supposed to be working for us, not the other way around. So I would be in favor of surveilling them in their conversations, because they're by far the most dangerous people in California. They're what some people refer to as assault politicians.
There you go. And that brings something to mind. I was thinking earlier, and the thought, it has not recently been in my mind until earlier today, but I was considering, and it's still out there. I still have time. I could run for office in South Dakota. I would be, if I were to choose to do it, I would be running as a House representative from my home district here in Sioux Falls. But my thought was, as a unique strategy, I could say, look, if you're hiring me, you're my boss, you have the right to know what I'm doing. I'll put live video out from my offices in Pierre. If as long as the office is open, you're going to see who's in there, and you're going to see what I'm doing, that I'm working for you. And I thought that would be a unique way to keep openness in the government, and to let my prospective constituents know that I actually am working. I don't think that would ever work, but anyway. Let me one couple other comments I want to get to here. C&T Designs and Arms says, face it, if you have purchased a gun, you're on a list. If you have purchased gun parts, you're on a list. If you believe in freedom, you're on a list. Yeah, Alex, I don't know how many darn lists you and I are on, but it's got to be a lot of them. And I'm hoping these lists get so big the government becomes afraid of us and leaves us the heck alone.
Well, that's a great point. And like you said earlier, I get that some people don't want to be on a list, but frankly, it's going to take a willingness on the part of many people to be on a list, because if they know that there are thousands, if not millions of us out there willing to stand and hold the line against their tyrannical measures, then they're going to think twice about doing so.
Woods says that my idea, he says that's way too good of an idea, Paul, therefore it likely is never going to work. Yeah. And honestly, I don't know. The logistics of that would be a little bit daunting. I can go live for half an hour longer from my home studio here, but to do that with video and audio from an office in the state capitol, I suppose I could make it work somehow. I don't know. CNT Designs and Arms says, how about every court hearing has to be streamed live? That would be an awesome idea. A lot of them are, and there's even some criminal stuff you can find online. But I'm really tempted to say that should be mandatory. That this, if it's in public interest, the public ought to be able to view it. And if you're working for the government, no matter which branch of the government, look, you work for us. We ought to be able to look at what you're doing.
Yeah, no, I agree, and I'm in the courtroom oftentimes 4 days a week, 4 out of 5 days of the work week, and it's always puzzled me why the courtroom is so secretive. Why do they care so much about people having recording devices, and whether that's video or audio? But then that was, of course, in my younger years, before I knew, sort of how government and politicians work. They like to work against the public behind closed doors as much as possible, and that includes the courts in many circumstances.
All right. Well, we are down by the bottom of the hour. We're a little over, but yeah, I mean, it's not that I have to anymore keep these things to a hard timeline. So, as I usually do, Alex, tell us about Forge of Freedom and what's been going on there lately.
Well, first of all, Paul, thanks for the invitation. I was glad to see that the Polite Society News was just on hiatus, that it wasn't, in fact, the end forever. So I'm glad to see that. And of course, that's for selfish reasons. I always enjoy our conversations, but I think that your voice in the Second Amendment arena and in the individual liberty arena is extremely valuable. So thanks for having me on, first of all. And then, of course, Forge of Freedom is a podcast I've started earlier this year. I've got 84 episodes out now, 85 coming out tomorrow, and 86 on Monday, which, by the way, is with Clayton Kramer, who is the author of numerous books, including Lock, Stock, and Barrel, The Origins of American Gun Culture. He's an expert in colonial era history, and his expert declarations were actually cited in the May v. Bonta decision or opinion. So he's active in lots of these Second Amendment cases circulating around the various federal circuit courts. And his work has actually been cited in Heller and McDonald, and most recently this May v. Bonta case. So if you're interested in the history of the Second Amendment and the history of gun culture in America, definitely check out the episode 86 with Clayton Kramer about his book, Lock, Stock, and Barrel, The Origins of American Gun Culture.
Very cool. To go off of what you started with, my intention when I decided to go on hiatus was just that, to cut back. I'm speaking to everybody viewing live and those who will be getting this on podcast later tonight. My intention was not to go away. I do not intend on going away totally. I intend on cutting back to very, 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 very part-time. Honestly, doing a show or two a month and then getting back into it as my personal schedule and my interest, either grows or wanes. It's my goal really is a show or two a month when I have time and when the planets align is what I'm looking at right now. So if you're a subscriber, thank you for subscribing. Please continue the subscription. I think that's going to do it for us today. Everybody, thanks for watching. Podcast listeners, thanks for listening, and we will see you next